Yeah, absolutely. The Southern District, Judge McGran out of the Southern District of Illinois issued a preliminary injunction on Second Amendment grounds in direct violation of the Bruin decision against Pritzker's assault weapons ban, and that had statewide implications, ultimately immediately restoring everyone's right to purchase what they call assault weapons and the magazine ban in the state of Illinois. So it was a significant ruling out of the Southern District of Illinois, in stark contrast of his colleague from Chicago, who that morning did not issue a preliminary injunction in that particular case. A little bit different fact patterns in those two cases. However, we were delighted to see that we had that ruling out of Southern Illinois.
And Ryan, both of those rulings, so one was in the Northern District of Illinois, one was in the Southern District of Illinois, two different federal districts, but they were cases that both involved the Second Amendment issue directly. Is that right?
Yeah, that's correct. Both of them did involve the Second Amendment issue. A little bit different of the fact pattern, but I find that interesting. You got two judges that have competing decisions, both in the federal district. And for those on the audience to understand, they both fall up to the 7th District Appellate Court. So obviously, probably very early Monday, if not already this weekend, you're going to have plaintiffs and defendants in each of those cases is seeking to have those decisions overturned. So now you're going to have a 7th District Appellate Court with two competing judicial decisions that are in direct competition with each other, and ultimately could end up landing on the U.S. Supreme Court's desk just for that alone right there.
Ryan, I wouldn't be surprised if there wasn't a bit of I don't want to say coordination between the two judges, but at least, I mean, the timing is awfully odd that on the same day you have these very differing decisions come down on the Second Amendment grounds as to whether the assault weapons ban violates the Second Amendment. And it seems to me there's a good chance that's not coincidental. It seems to me that if both judges realize this has to get resolved by the Supreme Court, so we might as well grease the skids and get this thing there. I mean, this is going to provoke a review by the Seventh Circuit for sure.
No, absolutely. And I mean, just examining, the lower court judges in the Southern District of Illinois, I find it interesting. And if anyone gets an opportunity to read the order, it's a very well-written order, and it's very favorable to the plaintiffs. But I find it humoring that he even calls out that the legislator enjoys the supermajority, and yet they don't have the ability to pass laws that are in direct violation of the Constitution. And I was pleased to see him directly acknowledge that our Illinois legislator is engaging in unconstitutional practices when they hold the supermajority. Why is that important? Well, when you hold the supermajority, they have time to think through and make a well-thought-out process and pass a well-thought-out law, and they still chose not to do that in this particular case. And as we all know, they took an innocuous insurance bill and at the 11th hour turned it into this assault weapons ban.
That sure sounds like deja vu, doesn't it? I mean, if you look at the cases that Tom DeVore has filed, which are on different grounds, part of that is going to some of these procedural things. With the three readings, with the.
Yeah, no, absolutely, Scott. You're right, and it's interesting because you have the state court challenges which are Tom's, which is why they happened a lot faster. Historically speaking, issues are going to move through state court faster. They're going to move through federal court, but there is actually no Second Amendment challenge in Tom's case. It's the matter in which the law was passed. The three readings rule violation by them not following the Illinois Constitution and balancing, whether the equities of this law are fair. And ultimately, what you have to understand is our legislative process allows for the people's participation. And when you have the supermajority, there's no reason to violate the Illinois Constitution and slide something through in the 11th hour. You can take your time to well vet a law out and passed it properly. But I think the Democrats in this particular situation and case knew there was going to be even pushback on their side. So they slipped this through at the 11th hour, changed an innocuous insurance bill in order to get this law to pass, because otherwise they may not have the muster to get it through the General Assembly, especially with about the change. They did it right at the end of a lame duck session, so to speak.
Yeah. So as I understand it, as you said, although we're very happy with this federal court ruling, it has no impact at all on Tom's cases. Is that right?
It does. It has no impact on Tom's cases whatsoever. Not that I want to see this happen, but, should the Seventh Court, remove the preliminary injunction, it doesn't have any impact on, his plaintiffs and his cases. They're still enjoying their preliminary injunction while this case is adjudicated. We don't want to see that happen by any means, but just so people understand, there is a strong distinction between the two cases, and ultimately we all want success for both of them to take place, right? We want to protect our Second Amendment issues, and we also want to stop and change the way that out of control Springfield passes laws and disenfranchises their citizens to participate in the legislative process. So both are constitutional issues. They just happen to revolve around a Second Amendment issue.
Yeah, I agree with you. I think we want to not just defeat this assault weapons ban. I think we want to have this thing quartered. I mean, we want to have any way you can take it out. I think we need to, because I think we need to send the message as the people to Springfield that we're not going to put up with this sort of behavior.
Yep, absolutely. And it's as we know in the several of the state court cases and now in the federal case, if you have an opportunity to read it, the federal judge in Southern Illinois often, and he finds that his colleagues of state's attorneys that submitted, information against this and the Sheriff's Association, and they're recognizing that these public safety officials are saying they don't support this law, while the state saying there's a clear and present danger and we have to put this law in play. And I think that only helps. And the more the people push back through their local elected officials, it really turns Springfield on its head. And they've never had to navigate this type of pushback like this from the people through their elected officials actually standing up and, trying to give them a voice. So it's been an interesting process to watch, and it's nice to see, the people join together and push back on these unconstitutional laws that keep coming out of Springfield. As we all know, we don't have to get into that discussion, but this is on the heels of the Safety Act and all the things that are going on with that. So while Republicans and conservatives may not have, the majority or the ability to get legislation through, we're going to push back and be a check and balance in the judicial branch if that's what it takes.
Ryan Cunningham, appreciate you so much for dialing in and giving us all this, giving us these updates as they happen sort of in real time and breaking it down for just sort of the everyday listener to understand what's happening at the federal level and here at the state level. Ryan Cunningham, thanks so much for joining us.
Yeah, thank you, guys.